Welcome to the Legal Influence Podcast, a show for influencers and content creators looking to grow thriving and influential businesses legally. I'm your host, Kate Cooper, and in today's episode, we're going to dive into some of the most important things to pay attention to when reviewing brand deal contracts. But before I dive in, I do have to provide some quick disclaimers. Nothing that I share today should be considered legal advice. Everything I'm sharing is for informational and educational purposes only. While I am an attorney, I'm not your attorney, and listening to this episode does not create an attorney-client relationship between you and I. So today I'm going to talk about what to pay attention to when you are reviewing a brand deal contract. Now, reviewing and signing your contract is a really important piece in the brand deal timeline. You want to make sure that you have a signed contract in place before you ever start doing work for a brand. And the brand should want to have a signed contract in place from you before they ever send you product. You both want to be totally on the same page regarding the partnership before anyone does anything. And your contract is going to serve as the roadmap for the rest of your partnership. It's going to outline the obligations of both parties. It should protect both parties. And ultimately, it's going to help manage the expectations between you and the brand throughout the campaign. And a good brand deal contract is going to anticipate and preemptively address potential issues and disputes. So it's really important to understand everything that is in your brand deal contract before you sign it. And this is going to be a legally binding agreement. And there are a lot of things that a brand can potentially include that can either shift the risk and liability onto you as a creator, or that may require you to do something that you may not have expected to have to do. I once had to provide a brand with analytics on a social media post that I had to make within 7 days of making the post. And if I did not do that, then it was considered a material breach of the contract. And it's totally normal and expected to have to provide a brand with analytics during an influencer campaign. That wasn't a big ask. But the fact that not providing those analytics within a certain period of time would rise to the level of being a material breach of the contract is pretty serious. That means that the brand would have a right to terminate the contract. There could potentially be issues if that happened. And if I didn't read that contract thoroughly and know what I was signing and agreeing to, I may not have known that there was such a limited period of time for me to provide those analytics. So today, I'm going to talk about some important things to pay attention to when you are reviewing your brand deal contracts, because it's really important that you understand everything that you are agreeing to. So the first thing that you need to pay attention to are the actual terms of your partnership. And these can also be referred to as the material terms of the partnership. And these are going to be the things that you discussed with your point of contact with the brand, whether you're communicating with somebody at the brand directly or whether you're working with somebody at a PR company. And these material terms typically include 4 things: the deliverables, the licensing and usage rights, the intellectual property rights, and exclusivity. And if you've listened to other episodes of the Legal Influence podcast, you've probably heard me talk about many of these things before. Things like your deliverables, the usage rights, and exclusivity should all factor into your rate for a brand deal. They're not the only considerations to keep in mind when setting your rate, but they're kind of the big terms that you need to know. So when you're reviewing your brand deal contract, you really want to make sure that all of those terms accurately reflect what you discussed and agreed to with the brand. So let's break down some of those terms one by one. So the deliverables are going to be the pieces of content that you're responsible for creating and possibly posting. And the contract should be specific in terms of the type of content you're creating, whether it's photos or videos or blog posts, the platforms you're responsible for posting on, if that's applicable, and any special considerations regarding the content, whether that's requiring you to use certain music or follow a campaign brief or edit the content in a certain way. That should be specified in the contract. The next material term to keep an eye out for are the licensing and usage terms. So this will be a provision that defines the usage rights that the brand is getting to your content, assuming that they're getting usage rights at all. So if you are working with a brand as an influencer, the brand may or may not get usage rights to the content that you create. If you're working with the brand as a UGC creator or a content creator, you're going to be licensing the content to the brand in some capacity. And again, the terms of this license should be really specific. So how can the brand use the content? Where can they use the content? How long can they use it for? What can they do with it? So you really want to make sure that that provision in your contract, you want to read it carefully because you want to make sure that you understand exactly what type of license you are providing to the brand. And you're also going to want to pay attention to the intellectual property provision of the contract because as a creator, you should be retaining all of the ownership to the intellectual property that you are creating. And that should be clear in the contract. As I just mentioned, you might be granting the brand a license to use the content in some way, but you're still the owner of that content at the end of the day. Now, you may come across language in a brand deal contract that says the partnership is a, quote, work made for hire agreement. And if that is the case, that should have been discussed with you during negotiations because those simple words totally change the equation. It now means that the brand will own all of the intellectual property rights to the content that you create during that campaign. And that type of agreement needs to be compensated appropriately. And if that's something that the brand just snuck into the contract without ever discussing it with you, chances are the payment probably isn't going to be adequate. That is a really big ask of a brand. So it's a really important phrase to be able to recognize, work made for hire. And hopefully you don't see it in a brand deal contract unexpectedly. But if you do, now you know what it means. So the last term to keep an eye out for is the exclusivity provision. Now, depending on the campaign, you may not have an exclusivity provision. If you're working as a UGC creator, you're probably not going to be exclusive to the brand. If it's an influencer campaign, on the other hand, it's fairly normal to have some sort of exclusivity agreement in place. And this means that you are agreeing not to work with certain other brands for a specified period of time, which means that you're agreeing to potentially lose out on revenue from other brand deals. And again, if exclusivity is going to be in the contract, this is something that should be discussed with you up front so you can factor it into your rate. Now, with that said, it is not uncommon for brands to sneak in usage rights and exclusivity that you did not discuss with them. I personally think this is a very deceptive, unprofessional tactic because, again, these are material terms of your brand deal and they affect your rate. So the terms really need to be discussed during the negotiation phase before you ever get a contract involved. So to be honest, I get a bad taste in my mouth when I see brands sneaking in usage rights or exclusivity requirements that have never been disclosed to a creator. Now, with that said, I also think that creators should be proactive and bring these things up during the course of negotiations, even if a brand doesn't mention them. Remember, you are your own best advocate. And so asking about the usage rights and exclusivity the brand is looking for gets ahead of the issue of finding surprise terms in your contract. And it also means that you have all of the information that you need to set an appropriate rate for the campaign. You'll also notice that when brands sneak in usage rights, it's typically full usage rights in perpetuity, a really, really broad license, much broader than you would be negotiating directly with a brand. And with full usage rights in perpetuity, that essentially just means that the brand can use your content in any way forever. And I can kind of understand why a brand might draft their standard contract language that way. They're really just trying to protect themselves as much as possible. But I personally don't think that that should come at the expense of content creators. And if a creator is giving up usage rights in perpetuity, they're really giving up a lot. And so realistically, a brand probably doesn't need a perpetual license. And again, I think if that is the ultimate desire of the brand, then they need to tell the creator upfront. It should not be a surprise term in a brand deal contract. Frankly, I just think that's a little shady. So when you're reviewing the terms, again, you want to make sure that they accurately reflect what has been discussed and negotiated with the brand. I've personally been in situations as a creator where I've discussed usage rights with a brand and we've come up with an agreement for a certain period of time, let's say 3 months or 6 months, and then I get the contract and it gives them usage rights in perpetuity. And in those situations, I think it was an honest mistake. Again, they were just using kind of their standard contract language. They never updated it. And it was easy to revise those contracts with the brands. But that's why it is so important to make sure that you're reading those terms of your contract carefully and that they accurately reflect what you actually discussed with the brand. So the next thing that you want to look out for when you're reviewing a brand deal contract is any provision that requires you to either do or not do something that is outside of the scope of the brand deal. So obviously, you're going to be responsible for providing a brand with deliverables. That's the whole purpose of the contract. But you may also come across other provisions that place certain obligations on you. For example, there may be a non-disclosure provision or a confidentiality provision that prohibits you from disclosing anything about the brand partnership or certain things that you may learn about the brand and their marketing strategy throughout the course of the partnership. There may be a non-disparagement provision, which means that you can't say anything negative about the brand. There may be a morality clause that allows the brand to terminate the contract in the event that you engage in certain immoral behavior. And that could be anything as serious as getting arrested or having some sort of public scandal, or it could be something more innocent, like being seen smoking in public or something like that. So ideally, if any of these terms are in your contract, they are going to outline the details and specific circumstances when they're going to apply. And in general, the more specific you can be in your contract, the better. That helps to avoid ambiguity and disputes down the road. But these types of obligations are things that you really want to look out for because they could affect the partnership as a whole. They could affect your relationship with the brand long term, and they could impact your potential liability. So it's really important to look through the contract carefully and identify any provision where you are either being asked to do something or to not do something. And I want to be clear that you don't necessarily need these types of provisions in your contract, but they are provisions that you may see a brand include. So I want you to be able to understand what they mean. And if you're looking for more information about the types of contract provisions that you should be including in brand deal contracts, I have a free guide called the Brand Deal Contract Checklist. And this breaks down 8 of the most important terms to include in your brand deal contracts in order to protect yourself as a creator. And that is going to be linked in the show notes. And again, it's a free guide for you to download after providing your email address. Thanks so much for listening to the Legal Influence podcast. If you enjoyed today's episode, please make sure to subscribe and leave a rating and review. And if you know any influencers or content creators who would benefit from this episode, please send it on to them. Talk to you soon.